Employee grievances. Employee grievances is a concern, problem, or complaint that an employee has about their work, the workplace, or someone they work with. This includes management. Something has made them feel dissatisfied and they believe it is unfair and or just on them. There are two procedures for maintaining effective employee relations. Grievances procedure. It is to protect the employees, to provide systematic process for hearing and evaluating the complaints of employees. They tend to be more highly developed in unionized companies than in non-unionized companies because this is specified in the labor agreement. The other one is the discipline procedure. It is to protect the company, provide a systematic process for handling problem employees. The goal of the good discipline system is to help employees perform better, but if they fail to respond, a procedure is needed for firing them as a last resort. Grievance defined is a complaint about an organizational policies, procedure, or managerial practice that creates dissatisfaction or discomfort whether it is valid or not. It is Paul Salipante and Winnie Bronan. They are the behavioral analysis of grievances, conflict sources, complexity, and transformation employee relations last 1990. Grievances referred to in Title 7E of the Labor Code is a dispute or controversy between the employer and the collective bargaining agent arising from the interpretation or implementation of the CBA and or those arising from the interpretation or enforcement of the company personnel policies for the adjustment and resolution of which the parties have agreed to establish a machinery or a series of steps commencing from the lowest level of decision making in the management and usually terminating at the highest official of the company. Causes of grievances. Most of the behavioral science literature suggests that grievances are due to seething discontent, and unfair management practices. Grievances arise because of 1. Differing application and interpretation of the CBA. Grievances frequently arise due to unclear contractual language that creates differing interpretation, application, and administration of its provisions. Number 2 is the perceived unfair treatment of the employee by the supervisor on ineffective or inadequate supervisions. It is when supervisors behave dictatorially, when they refuse to listen to employees' complaints, when they are unfair or inconsistent in disciplinary actions, when they give inadequate or unclear instructions, or when they fail to keep employees informed. Number 3 is the violation by management of the labor agreement or violation of the law. It is the definitely arise of the employee perceives that management violated certain provisions of the law or violated any provisions in the CBA. Number 4 is the grievances inspired by the union leaders. Some union stewards are oriented toward submitting grievances and constantly look for opportunities to do so, even when an offended employees decide not to file a grievances. Some stewards will file a grievance in the name of the union. Other union stewards are oriented toward resolving problems and trying to do so without submitting a formal grievance. Number 5 is a lack of clear company labor policy. This is a cause confusion or misunderstanding on the part of the employees, especially if there is no union to protect their interest or no effective employer-employee channels of communication exist. Employees should be provided with information about company policies and regulations to avoid misunderstanding and conflict.
who can file a grievance. A grievance can typically be filed by an individual or group of individuals who feel that they have been wrong or mistreated by an employer, organization, or government agency. So that specific rules and procedure for filing a grievance may vary depending on the context, but in general, individuals who are covered by collective bargaining agreement, employment contract, or administrative regulation may have the right to file a grievance. So in some case, individuals who are not covered by any formal agreement or regulation may also be able to file a complaint or appeal decision through a grievance process established by the relevant organization or agency. So it is important to consult with an attorney or others legal expert understand your right and option of filing grievance in your specific situation. So ang grievance kay mao ni siya ang usa ka pangkalahatan nga formal nga proseso para sa paglutas sa mga reklamo o mga dili pagkaunawa nga naay kaugnayan sa trabaho o naay mga relasyong kontrata or organisasyon. So ang mga partikular ani na mga tuntunin ay usa ka pamaagi para sa pag-andam sa reklamo nga pwede mausab pero nakadepende siya sa context. So pareha sa organisasyon sa collective bargain agreement o sa mga nakaapan sa batas o sa regulasyon. So sa pangkalahatan diay ang usa ka direkta nga naapektuhan usa ka isyu or kasinabtanay kay pwede ra ka magsampa og reklamo ana. So example, pwede magsampa og reklamo ang usa ka empleyado kung sa iyang pagtan-aw dili patas ang pagtrato sa ilang o pagdiskriminasyon sa ilang mga empleyado. So ilang mga kaso ang isa ka kinatawan ay pagtaguyod sa pwedeng magsampag reklamo sa ngalan sa apektado nga tawo tulad ng isang kinatawan ng union o sa bugado. So grievance procedure in unionized firm are formal process for resolving dispute between employees and management. These procedures are set forth in the collective bargaining agreement CBA negotiate between the union and management. So in some case, individuals who are not covered by any formal agreement or regulation may also able to file complaint appeal decision through a grievance process established by the relevant organization or agency. It is important to consult with attorney or other legal expert to understand your right option for filing a grievance in your specific situation. From labor or set, it also helps ensure the employees are treated fairly and that their rights are protected under the CBA. So usaday kapamaraan sa grievance sa mga unionized companies kay usad din siya ka importante nga aspeto nga para sa relasyong pamamahala o paggawa dahil ito ay nagbibigay ng mga isang formal na mekanismo para sa mga empleyado nga maghain ng mga alalahanin at grievance sa kanilang mga employer. Ang mga pamarang ito ay madalas na itinakda sa pamagitan ng kolektibong pakikipagsundo sa pagitan ng union at mga employer o karaniwan ni siyang ginagamit sa collective bargaining agreement. So ang usaday ani ka benepisyo o pamaagi ng grievance ay usa ka paghatag og mga structure nga proseso para sa paglutas sa mga hindi pagkaunawaan o makatabang ni siya kayan ang mga malalang konflikt at legal na aksyon sa pamamagitan ng pagbibigay ng malinaw na alituntunin kung paano harapin ang mga employer at union. Sa mga empleyado ay dinig at siniseryoso ang kanilang mga alalahanin. So sa parehang oras di ay gayon pa man ang mga pamaraang grievance ay maaring maging komplikado at matagal at maaring maglagay ng pasanin sa parehong employer at sa union. Bilang karagdagan ng proseso ay minsan ay maaaring maging adversarial sa bawat panig na sinusubukang manalo ng mga koneksyon o protektahan ang kanilang mga interes.
Representative or shop steward is an employee of an organization or company but is also a labor union official who represents and defends the interests of his or her fellow employees. The position is a voluntary position and is generally elected by fellow workers through democratic election. On occasion, this position can be appointed by a higher union body. The role of the union steward is to represent the non-management employees, commonly referred to as the rank and file, and to be a link and conduit of information between the rank and file and the union leadership. Duties of a steward vary in accordance to each labor union's constitutional mandate for the position, but generally include informing the workers of their rights under the collective bargaining agreement or CBA, monitoring and enforcing the provisions of the CBA, and ensuring the employer compliance with federal, state, and local laws. Additionally, when an employee is believed to have violated company policy or the CBA, the steward duties are to represent and defend rank and file employees in inventory interviews in according with employees' Weingarten rights that are reasonably expected to result in disciplinary action. And through the grievance procedure, collective bargaining agreements generally include a steward clause in which the union steward be granted the right to engage in union activity at work and conduct union business on work time. Additionally, the clause will grant the elected union officials, stewards, and members leaves of absence for union business. Union contracts generally include what is called a no-docking agreement, in which the steward is typically permitted to use part of his or her work day or work week for union-related duties, such as disciplinary meetings, grievance investigations, arbitration, and contract negotiations without any loss in pay or benefits. Is grievance handling. Grievance handling is the management of employee dissatisfaction or compliance, what you call favoritism, workplace harassment, or wage cuts. By establishing formal grievance handling procedures, you provide a safe environment for your employees to raise their concerns. You also create a channel to explain your policies and rationale for actions or decisions. Why it matters. As an employer, it is best to handle grievance in an amicable and supportive way to avoid unnecessary escalation and negative feelings. Grievance handling procedures also allow you to identify and address unacceptable or unlawful practices quickly.
Arbitration. Arbitration is a private process independent of the federal government or judicial system through which parties with adverse interests submit their disputes to an impartial arbitrator for a solution and agree to accept the decision and arbitrator as final and binding. There is generally no automatic right arbitration. The arbitration process. When an employee dispute does not resolve in their grievance process, the next step can be arbitration. Employers or unions oftentimes required arbitration in the event of an employment dispute. The use of arbitration often occurs in both federal employee and private employees cases. Although an employee is permitted to file a grievance and represent himself or herself through the steps of the grievance procedure, Only an agency or union representative may usually invoke arbitration. In order to qualify, your union must authorize arbitration for it becomes an option. Arbitration can apply to all types of disciplinary actions, letters of warning, suspensions, or terminations. For federal employees, arbitration is far more inclusive than the merit system protection board, where federal employee can only appeal cases involving more than 14 days of suspension. Arbitration is equally broad, generally for private sector employees covered by a CBA between a private company and a union. Arbitration is a right provided through each union collective bargaining agreement. If an employee wishes to pursue arbitration, he or she must usually obtain their union's permission to do so. A union usually delegates this task to a committee independent of the union leadership, and a decision is made. If a union approved the case, it moved forward to arbitration. If not, a federal employee's only option may be to pursue his or her case at the MSBP, the Equally Employment Opportunity Commission, or EEOC, or at the Office of Special Counsel, OSC. Collective Bargaining Agreements, CBA. In the labor relation context, a process for a union and employer to resolve disagreement concerning interpretations or applications of an existing collective bargaining agreement. Typically, parties agree on a process for a
Scope voluntary arbitration. Voluntary arbitration represents the final stage in the dispute resolution process. The grievance procedure does not always result in an acceptable solution because when the deadlock occurs, the contracts call for arbitration. So arbitration is a quasi-judicial process in which the parties agree to submit an unresolved dispute to a neutral third party for binding settlement. Both parties submit their positions and the arbitrator makes a decision. So for example, no, a company and employer is na ay problema. For example, nareklamo ang employer o kanang about sa minimum wage, for example. So, para ma-settle nila ang kuan, kay naa may rights ang employee nga moreklamo about sa minimum wage, and then naapoy rights nga ma-hear ang side sa company. So para mahitabo na kanang so need nila sa both parties need sa employee nga i-gather iyang documents og ang company pod iya pong i-gather ang iyang documents, then mao na day na nga naay arbitrator. So under Article 261 of the Labor Code, as amended, the following disputes are subject to the original and exclusive jurisdictions of voluntary arbitrator or panel makes a decision. So ang arbitrator mao ang magdesisyon kung kinsa ang naadjay problema sa both parties.
The first is unresolved grievances arising from CBA interpretation or implementation. These include CBA violations which are not gross in character, meaning flagrant and or malicious refusal to comply with the economic provisions of the CBA. Two is unresolved grievances arising from personnel policy enforcement and interpretation, including disciplinary cases. Three is under Article 262 of the same code, all other labor disputes including unfair labor practices and bargaining deadlocks may also be submitted to voluntary abrogation upon agreement of the parties. Four is all unresolved wage distortion cases as a result of the application of wage orders issued by any regional tripartite wages and productivity board in establishment where there is collective bargaining agreement of recognized labor union. Five is all unresolved disputes, grievance, or other matters arising from the interpretation and implementation of productivity incentives program which remains unresolved within 20 calendar days from the time of the submission of the labor management committees. Authority of an arbitrator. A voluntary arbitrator is defined as any person accredited by the National Conciliation and Mediation Board (NCMB) or anyone named or designated in the CBA by the parties to act as their voluntary arbitrator. So bisag kinsa nga kuan nga gi-recruit sa both parties na mahimong arbitrator mo'y na ay rights nga i-check ang ilahang both documents. Articles 261 or 262 to 262 of the Labor Code provide pertinent information about jurisdiction of voluntary arbitrators, procedures to be followed, and cost of arbitration. A decision of award rendered by voluntary arbitrators is final and executable. As a general rule, the authority of an arbitrator embraces or covers the following. So first is general authority to investigate and hear the case upon notice of the parties to render an award decision based on the contract and record of the case. So naa sila authority to investigate and hear the case sa both parties. Number 2 is incidental authority to perform all acts necessary to an adequate discharge of his duties and responsibilities like setting and conduct of hearing, attendance of witness and proof documents and other evidences, fact-finding and other modes of discovery, reopening of hearing. So, i-gather na dahil nila ang mga kuan, then magtapok na dayon sila para makandak og hearing. So, need ang both attendance sa employee o employer, for example, para makahimo og decision ang arbitrator. Para maka-decision na ang arbitrator o para ma-investigate og tarong ang ilahang case. So, next is a special power in aid of his general contractual authority, like the authority to determine arbitration of any particular dispute and to modify any provisions of existing agreement upon which a proposed change is submitted for arbitration.
Processing grievance. Processing a grievance refers to the step-by-step procedure followed to address and resolve a formal complaint or concern raised by an employer or a group of employees regarding workplace issues. The grievance process typically involves various stages, including identification of the issue, gathering information, evaluating the merits, and working towards a fair solution. Here is an overview of the steps involved in processing a grievance. First, identification of the issue or the issues involved. The first step is to identify the main problem or concerns raised in the grievance. This requires understanding the nature of the complaint and clarifying the specific issues being addressed. For example, an employee files a grievance stating that they were passed over for a promotion despite meeting all the qualifications and having a good performance record. Second, Developing the factual basis or background. Gathering relevant information and evidence is crucial to support the grievance. This involves collecting facts, statements from involved parties, reviewing documentation, and considering any witness or supporting evidence. It is important to establish a clear factual background to understand the context of the grievance. For example, in the investigation process, HR gathers relevant information such as performance reviews, promotion criteria, and any document incidents or complaints related to the promotion decision. Steps number 3. Determining the contract provisions involved. Employment contracts often outline the rights and responsibilities of both employers and employees. In this step, the relevant provision of the employment contract are identified and examined to determine if they are relevant to the grievance. This helps in evaluating whether there has been a violation of any contractual terms. For example, in the HR reviews the employment in contract and finds that there is a clause stating that promotion decisions should be based on merit and fair evaluating of qualifications and performance. Step number 4. Evaluating the merits of the grievance. This step involves assessing the grievance in the light of the factual background, applicable rules such as the employment contract and company policies, and legal regulations. The merits of the grievance are evaluated based on criteria such as whether the grievance demonstrates a violation of contract terms, discrimination, or a breach of company policies. For example, HR evaluates the employee's qualifications, performance record, and the promotion decision-making process to determine if there was a violation of the employment contract or any discriminatory practices. Step number 5. Working out a fair and just settlement. The ultimate goal of the grievance process is to reach a fair and just settlement. This can be achieved through various means, including mediation, negotiation, or arbitration. Effective communication and collaboration between the parties involved are essential to find a resolution that addresses the concerns raised by the grievance while maintaining a positive work environment. HR initiates, for example, initiates a mediation between the employee and the supervisor responsible for the promotion decision. Through open dialogue and negotiation, they reach a resolution where the employees receives compensation, additional training opportunities, or future consideration for a promotion. Grievance procedure in non-unionized firm. What is grievance procedure in non-unionized firm? In non-unionized firms, grievance procedures are the internal process established by the organization to address and resolve employees' grievances or complaints. These procedures provide a structured framework for employees to raise their concerns and seek resolution within the company. So, by establishing grievance procedures, non-unionized firms demonstrates their commitment to addressing employees' concerns and maintaining a positive work environment. These procedures help promote transparency, fairness, and effective resolution of grievances, ultimately contributing to employee satisfaction and organizational harmony. A company without any union must formulate a grievance procedure for the guidance of its supervisors and employees. Grievance procedures usually involves in these following steps. First, presentation of employees' problems to the foreman or supervisors who is expected to settle the problem within a specific period. Second, if not satisfied, the employee can elevate the complaint to the next higher level to resolve the grievance. Third, the problem or case may be taken to arbitration for final decision if no satisfactory solution has been reached by the above procedures. So meaning, the specific steps and procedures within a grievance procedure may vary from one organization to another. It is essential for companies to develop their grievance procedures in compliance with applicable laws and regulations while also considering the unique needs and culture of the organization. By establishing a clear and transparent grievance procedure, non-unionized firms can provide employees with an avenue to voice their concerns and work towards resolution within the company. Procedures in handling of grievances vary among companies. Here are some common elements typically found in grievance procedures in non-unionized firms. First, grievance committee. So, a grievance committee is a group of individuals within an organization responsible for reviewing and addressing employees' grievances or complaints. The committee is typically comprised of representatives from various departments or levels of the organization, including management, HR, and sometimes employee elected representatives. Its main purpose is to provide an impartial and objective forum for addressing employees' concerns and ensuring fair treatment. Second, grievance appeal procedure. A grievance appeal procedure outlines the steps and process for an employee to appeal a decision made in response to the initial grievance. It provides a mechanism for employees to challenge the outcome of the grievance process if they believe the decision was incorrect, unfair, or inadequate result. That's all. Thank you.